Namaste. Is coronavirus outbreak a force majeure event? The barrage of calls received by advocates from clients all over is predominantly to clarify their doubt over whether the present situation would amount to a force majeure invocation. Parties from both ends of the spectrum, that is, those who wish to invoke the force majeure clause and those who could stand to lose if the force majeure clause is in fact invoked, have expressed concerns over this issue. Whilst most of us have held webinars on various topics that interest us, the common man is what I shall attempt here, the common man's perspective. Contractual obligations not being met with results in the requirement to consider whether the contractual responsibility has been adhered to or not. If such clause exists and breach of contract is claimed, then the party is required to prove that it has taken all reasonable steps to avoid or mitigate the occurrence, that such a force majeure event is beyond its control, that such occurrence has in fact delayed or denied or rendered the party the opportunity to comply with its end of the contract, that the performance of contract was impossible, that such an occurrence would in fact take place was beyond the imagination of the party to foresee. The first question is whether such a clause exists in a contract, and if so, how has the force majeure clause been worded? Whether words such as disease or epidemic or pandemic have been expressly used. If not, any such equivalent. Otherwise, does the clause mention act of God or his majeure? If then, would this pandemic be considered to be an act of God? The next is whether the said industry or business did in fact suffer so as to render the party completely unable to perform. The economics of it or the disturbance in performance of the contract may not really suffice. Whether the performance is dependent on a third party compliance, such as supplier failing to deliver, operation of a late time, demurrage, etc., whether that would in turn be sufficient. If costs have to be incurred during such time, and costs have been incurred, then who is to bear that additional unforeseen costs? Whether such force majeure would render the contract redundant, whether it is suspended temporarily or terminated as a result, is to be seen. If the force majeure clause is invoked, then the notice of the same is also to be sent to the other side. When such notice is sent, the reasons, details of failure of the performance, evidence in support of your claim, they're all absolutely necessary, and whether such invocation is directed towards the extension of time, conciliation, mitigating the damage, or towards just suspension of performance for a given period of time. All of this is necessary in your notice. The notice is normally sent with regards to the consequential liabilities of non-performance and how the same could be avoided. This notice is basically to convey the suspension of obligations. A force majeure clause would ideally include situations such as war, hurricanes, terrorism, fire, a government clampdown. Any of these could be part of a force majeure clause. If diseases are mentioned, then plague, any specific epidemic, pandemic or widespread illnesses would have to be mentioned. An exhaustive list which covers most dangerous diseases or a narration of what could constitute a force majeure is necessary in a contract. If details of conditions that would have to be mentioned in the event of invocation of the clause, if such details are there, then the scope of dispute over the invocation of this clause is considerably lesser. In contracts that do not have a force majeure clause, In these situations, parties tend to fall back on contracts wherein Section 56 deals with an impossible act, wherein the contract is frustrated by the non-performance in view of an unforeseen or unavoidable event. Completion of the performance of contract is impossible due to the occurrence of an event. Therefore, the contract is considered void. This is a statutory remedy as opposed to the contractual remedy by way of a force majeure clause. Section 65 is of utmost importance as it practically is a status quo ante section. It works towards the restitution of the contract, rendering to be functioning in the same manner and position as it existed prior to this event happening. Therefore, 56 and 65 are connected. Now, 65 only comes in such situations where if one party is aggrieved that the other party invoked 56 and by rendering it void, he would in fact gain by it, then the other party invokes 65 to state that he cannot claim 56 because he is going to gain by it, and therefore the contract should go back to the time prior to the event happening. Now, Section 32, seen by many as a virtual force majeure clause, is in fact very different. It is ultimately a statutory remedy. Difference is force majeure clause does not necessarily invalidate a contract, whereas 32 does. Now, Section 32 of the Indian Contracts Act is with reference to a contingent contract. It's contingent on a happening or not. This was dealt in the Satyavrata Ghosh case, but according to me, this is not relevant in the present context. The reference in the landmark judgment was with respect to the word impossible. In the energy watchdog case, it was the energy watchdog versus the Central Electricity Regulatory Commission. The courts in this judgment has in fact held that the last 3 lines of the judgment, it covers the force majeure clause and states that Section 56 would not apply. What the courts had held that in the last 3 lines, that in an event, if an event is covered under force majeure, then 56 would not apply. This could also be interpreted to this extent that if the force majeure clause did not cover such an event, then 56 could apply. Now, frustration of a contract arises only when there is no force majeure clause in the contract. Therefore, the lack of specific force majeure clause gives rise to the usage of the frustration clause, but it is used only in extreme circumstances. Impossible, though determined to mean not literally impossible, it is important to establish the near impossibility so as to evoke the frustration clause. A frustrated contract is a contract that, subsequent to its formation and without fault of either party, is incapable of being performed due to an unforeseen event or events, resulting in obligations under the contract being radically different from those contemplated by the parties to the contract. Some wonder as to the enforceability of a fructified right. How could one recover his dues on the contract if the performance of the contract is complete? And in view of the courts being closed, how is one to enforce these claims? When time is the essence of the contract and the party is ready and willing to fulfill his obligation and is unable since the concerned authorities are not functioning, would courts then refuse to grant time or would use inherent powers to grant further time? Would courts be empowered to do so would depend on the provision and the act and the said matter that it comes under. When a clause does not exist, it is understood that during the time of entering into the contract, such an event was inconceivable and had therefore not found its way into the agreement. Therefore, the impossible is invoked. Now, force majeure cannot be used to cover neglect or underperformance. When external forces beyond any being's control has created a scenario wherein the party, much to its dislike, has been unable to keep up its side of the contract, force majeure could be invoked provided it has been covered under the contract. Mere excuses to cover up the disinterest due to the viability or non-profitability in view of the change in circumstances cannot be a force majeure. Price measure is a term used in lighter weighing by traders abroad when they refer to a party walking away from a contract when the price is not working in their favor. Therefore, when one invokes the force majeure, in all earnestness, one has to display that all measures were taken immediately to mitigate the losses, steps were taken to overcome the hurdles, alternative ideas were implemented, etc., so as to establish the credibility and the genuineness in attempting to overcome the hurdle. If courts are to decide, it would be based on the terms and conditions specified in the contract, interpretation of such terms, terminology is important, the background of the erring party, the genuineness in attempting to overcome the impact of the event, the future intent, and the steps taken to mitigate the damages. Each case would be decided on its merit and cannot be equated to another unless such other case is directly relevant to the one in question. The direct question posed by clients expecting a simple, straightforward answer is this: is COVID-19 covered under force majeure? The courts are yet to determine the same. The central government, though by way of an office memorandum issued on 19/2, clearly stated that the spread of coronavirus should be considered as a case of natural calamity and that force majeure clause may be invoked. That being clear, I hasten to add that the gentle disclaimers noticed in the language are: wherever considered appropriate, following due procedures. These references are made with respect to the supply chain, and the said office memorandum arises out of wherein they sought a clause or a paragraph in the Manual of Procurement of Goods 2017. Therefore, it is clear that the government in the given circumstances have clarified that it should be considered a natural calamity, though the same cannot be universally utilized in all areas of trade or business. Such memorandum or memoranda may find no legal sanctity in courts. It could nevertheless be used by parties to fall back upon if they do come under the same category. In the most recent judgment, the Bombay High Court refused to accept the force majeure excuse when an exemption was sought for by the steel importers. The Bombay High Court clearly stated that since steel has been declared as essential services, restraining the encashment of letter of credit by the exporters could not be granted. The judgment was widely read. The judgment referred by the Bombay High Court was the Energy Watchdog judgment and the Satyavrata judgment. These discuss the impossibility with respect to Section 56. The important aspect is that the Bombay High Court noted that the letter of credit was an independent transaction with the bank and that the bank was not concerned with the underlying disputes between the buyer and the seller. Now, it is apparent that one cannot assume that a party is covered either by force majeure clause or seek redressal under 56 of the Indian Contracts Act. based on the government's decision to broadly consider the present situation as a force majeure event. Even when a specific clause does exist, if it is constructed in such a manner that defines force majeure as, let's say, inability to transport goods when, in such a case only it can apply to the specified area or the area of the transportation of goods. If the party is required to comply with more than just that, then the party may not be able to claim such exemption on, say, production, preparation, sourcing, etc. Whereas if the construction is in such a language, it contains the words such as includes and covers all areas, then the party may seek shelter under the clause. The emphasis is on the language, and the language is important, as some parties, when specifying the force majeure clause, they could provide for immediate termination on occurrence of force majeure. Some could choose to put it on hold till the event subsides. Some could provide for a time frame where, upon notice, either could terminate the contract. That is, if it is non-performance, and if the non-performance is prolonged beyond the time or damage is rendered permanent. A similar such clause is Material Adverse Effect Clause, MAE, which applies when a material adverse change occurs. Therefore, a party can choose to either cancel or retract from the transaction if such change occurs. Both force majeure and Material Adverse Effect Clause, they are clauses that are inserted so as to ensure that one is not hauled up for a breach of contract. A drawing, a plan, a website, or a development of software, if it could be done within the confines of home and did not require the presence of a party in any particular location, such party would find it difficult to claim lenience under the force majeure clause, and also frustration. To claim that it is neither a breach nor a default of the conditions of the contract, one has to prove the definition of force majeure. The superior or greater force that cannot be anticipated or controlled. It is an unavoidable catastrophe that alters the usual course of events. Act of God, that is an occurrence by forces of nature, not man-made, to mean that humans had no control over the incident and that no agency could regulate it, and when it does happen, there is no control over it. The force majeure covers both natural calamities as also the other extraneous circumstances such as war, strikes, inundations, epidemics, pandemics, all of it. Force majeure clause has not evolved to a standardized clause so as to contain common specifics. Therefore, mere covering of several examples of what constitutes a force majeure need not necessarily protect a party. It is ultimately the discretion of the courts to look into the content and decide whether to accept or reject the content based on the merits of the case. Parties could, besides the force majeure clause, claim on price adjustment clause, exclusion, liability of non-performance, etc., whether the liquidated damages clause is incorporated, and if so, how is it to be read with the force majeure clause. With respect to claim of liquidated damages, the aggrieved parties are at liberty to move appropriate courts seeking damages. However, the onus would be on the opposite party to prove whether the aggrieved party is entitled to claim such liquidated damages. In the guidelines to major ports, the Government of India on the 31st of March specifically dealt with issues relating to force majeure and confirmed that force majeure may be invoked. The Government of India goes further to state that they shall not impact or dilute the operation of ports and that the operation shall continue. The reprieve is that the period of completion of projects can be extended, waiver of penal clauses could be considered on a case-to-case basis, and performance of obligations could be deferred. These relaxations and breathers have been rolling in from all quarters. The RBI on the 27th of March, issued a notification that all farm loans, including retail, agricultural, banks, NBFCs, financial institutions, they could grant a moratorium of 3 months on repayment. The SEBI introduced relaxations related to matters wherein compliance is pending with respect to listed companies. Courts have extended the statutory period of limitation and notified extension of interim orders. Ministry of Corporate Affairs, Ministry of Finance, Department of Direct and Indirect Taxes, they have all extended the compliance time frame. Suspension of Section 7, 9 and 10 of the IBC, that's the Insolvency and Bankruptcy Code, for a period of 6 months if the said pandemic continued beyond 30th of April is in the offing. And the threshold for default has been raised from 1 lakh to 1 crore. This is in order to prevent the filing of insolvency proceedings against MSMEs, that is the micro, small, medium enterprises. The audience is to be passed. A detailed analysis of the definition of the force majeure and circumstances under which it can be invoked has been laid out in landmark judgments of the Supreme Court. It has been established that mere difficulty in adhering to the terms of contract by one party does not absolve the other party from performing its obligations in the contract. The party claiming relief from its obligations must be able to show that the very foundation of the contract has been upset due to the occurrence of an event that it is claiming to be a force majeure event. In the landmark judgment of Energy Watchdog, the courts have clarified that unless the condition precedent in a contract has been majorly affected, the contract on the basis of such condition precedent becomes impossible to perform due to an event or subsequent events. Such an event or subsequent development cannot be considered as a force majeure event, leading to frustration of contract. In the above landmark judgment of the Supreme Court, they also referred to a House of Lords judgment wherein it was observed that the party seeking relief to frustration must have tried alternatives and approaches to performing its obligation of the contract. The House of Lords had in that matter held that even though the contract has become more onerous to perform, it is not fundamentally altered. When it comes to tenancy, the courts have said that there cannot be a blanket waiver of rent by tenants unless it has been specifically agreed upon in the rental agreement. Only in a situation where there is severe damage to the property, where the tenant is rendered homeless and is unable to live in a tenanted premises, then it could be considered a force majeure event. The stance taken by the courts in earlier judgments, the central government under the Disaster Management Act that has come into force now, under Section 10 had directed the states to take necessary action for waiver of rent for a period of 1 month. Now the Supreme Court judgment, as I've already mentioned to you, spoke about the agreement should be specifically have the clause wherein one could forfeit the rent for a certain period of time if the landlord had accepted the same, and a tenant need not pay the rent if he was rendered homeless due to extreme circumstances. But under the Disaster Management Act, the government has specifically stated that they should consider waiver of rent from tenants who are workers. Therefore, this issue would arise as to who would fall within the definition of a worker, and the government order does not state anything with respect to lease agreements entered into for commercial purposes. With the Indian government considering this event at this point of time to be a natural calamity, one wonders if the dynamics of it all would change if it's declared that it was created and not a natural disaster. A lot has been circulating on the trade agreement signed between the United States of America and China, wherein a force majeure clause came to be inserted in the event of a natural disaster or other unforeseeable events that would delay the compliance. Parties then could consult with each other. Now, the strange clause, I say strange, since such clauses are normally not part of, or are normally part of commercial contracts and not such contracts. With news of thousands signing up on class action suits, I'm told a few have already been filed to sue China, releasing biological warfare, some suing even the WHO, the World Health Organization, for negligence in actually covering up the COVID pandemic. The issue of determining whether it's a natural disaster or man-made will remain to be seen. It will nevertheless fall within the meaning of force majeure. Having said that, it will not alter the fact that force majeure is a force to be reckoned with. I will end with just a message. It is to all the health workers of India. May the force be with you. Namaste.